Welcome to day 12 of the Kouri Richins trial. This morning, we're going to watch the state try to get in what they should have tried to get in on redirect examination of Carmen Lauber. This morning is going to be all oral argument, legal argument. I can't wait for it. Let's check it out. Good morning, beautiful humans. We are day 12, Kouri Richins trial. Yesterday, I left for an hour and the whole world exploded. By the time I got back, trial was called for the rest of the day. Parties were ordered to do all kinds of stuff. Turns out they didn't really have to do all that much stuff. So we're going to find out today, and Allie's going to be joining in a moment, but we're going to hear argument this morning, but it's changed. The argument has changed in terms of what we're going to be hearing, because if you're not aware, if you don't follow Twitter, I was posting it all night last night. I had gotten my hands on the orders, which were filed publicly, but for some reason were difficult to get. We got an order. The way that it went down yesterday is this issue with Bloodworth really needing to get these prior consistent statements that he believes exist regarding Carmen Lauber. He needs them in because while everyone was so busy shitting on the incredibly clunky and painful cross-examination of Carmen Lauber by Lewis, what everybody forgot is that Brad Bloodworth completely shit the bed by not doing exactly what he's trying to do when he's supposed to do it, which is in redirect. That's when that was supposed to happen. Redirect examination exists on this planet for that exact purpose, to rehabilitate the witness after cross. He didn't do it. And for days, we've been watching him scurry around trying to figure out a way to get it done. So now it's left us to, 11 o'clock? That's when I left yesterday, when this whole thing takes place while I was gone. And, of course, my brilliant and beautiful co-host nailed it immediately. And the proof's in the pudding. I mean, she identified what the issue was going to be. Not one lawyer in that room brought it up. The judge didn't bring it up. But to his credit, my bro crush, my judge crush, figured it out when he went back into chambers. And so it goes down. He makes an order, gives a 6 o'clock deadline to the defense, saying, I need you guys to go through, get everything figured out in terms of the statements and why you think that they shouldn't come in or they should come in and what statements they are, the mechanical stuff. In the meantime, what Allie had said early that day becomes the court's order, as the judge literally echoes exactly what Allison was saying, which was that, the whole arm thing, the before, that the prior consistent statement had to happen prior to them putting the thumb on her, whatever would have caused her to lie. So it's a timing issue. So that order hits, I think, it just before 3 o'clock Mountain Time. We had tweeted about it at about 2 o'clock Mountain Time, and Allie supplied me with the case. So at that point, Bloodworth gets the order. Bloodworth then shoots an email over to the defense team saying, all right, here's the deal. Forget about, I'm not going to do 801. I'm going to go 106, which is the completeness doctrine. So that's where we stand today. And then the defense files their thing prior to 6 o'clock saying, okay, Bloodworth said, he's abandoning 801. He's going 106 completeness doctrine. That's the way he's going to try to do it. So we'll figure it out when we get into court this morning. So that's where we're at. That's literally where we're at this morning. So it's going to be an interesting morning. I cannot see. I mean, short of him recalling Lauber, which is just, I've never seen it before. I've never seen it before. Because again, I mean, it's why redirect exists. I mean, the reality is that Bloodworth did not want to be Lewis. You guys remember how brutal that was? Her trying to go through the transcripts to refresh Lauber's recollection to everything. And everybody's like, oh, she's not prepared. She's not so unorganized. No,
was he prepared to do that?
That's what I just said. Right. My beautiful, brilliant co-host just popped in instead of running downstairs and getting on the live.
I'm doing it.
I mean, we're all waiting. We're all waiting.
What about the dog? Should I put him out and then we'll let him in?
What did you say something about the dog?
Yeah, I'll let him out. We can let him in.
Did you say something about the dog?
What the dog doing?
He's been so pissed at us for since we got back from Louisville. He's been really cold shouldering us. It's been very not sleeping in our room. It's been he's really, really giving us the shit. Side-eyeing me constantly. I gave him such a glorious walk yesterday too. So, all right, let me pull up the court. We haven't missed anything, y'all. It is, it's right here. Oh, maybe we did. We'll see.
We're going to read the things. We can get some blue.
Oh, whoa. Oh, wait, this is yesterday anyway. Wait, dude. Go downstairs. What? All right, hold on. Aren't you dressed?
Hey, Siri.
You're acting like you're nude.
Hey, Siri, where are you?
Oh, my God.
Hey, Siri, where are you?
Wow. This is how the sausage is made over here. This is how the sausage is. Whoa, look. I didn't know it does that nice little thing when my voice moves because I'm always on camera. All right, she's left. She's left the building. All right. So first of all, I'm on the wrong day. So there's a fail. There's the first fail of the morning. Let me back this out. Let me get in here. Okay. All right. Allie wants to read the documents. I don't think it's necessary.
All right, finish.
Yeah. I don't they just weren't lengthy. All right. So we'll have 3 minutes of blooping time, which, over here we love the bloopage. All right. So let me pull it up. Because I predict this is not. So the jury
231-500-139, State of Utah versus.
We will read them, but we'll read them. I don't want to lose viewers because they want to be watching this shit. So we'll read them during the break. I have a sneaking suspicion this is not going to take long this morning because I'm trying to recollect. I think the judge has already shot down the 106 completeness concept. When Bloodworth was trying to get the entire transcript in initially. See, because that flipped. First, it was Bloodworth, I want the whole thing in. Defense is like, what? No, maybe. Judge is like, no. Not maybe, no. It's way too many potential issues with 962 pages or whatever the hell it is. So, and I thought that when he asked Bloodworth, he's like, give me a legal reason, an actual rule of evidence that allows me to put that entire transcript in. And that's when Bloodworth comes up with the whole, well, I'm trying to rehabilitate the witness. That's all. So in that situation, it's not hearsay. So Dude, just just hop on. I'll handle the dog.
Kouri Richins, counsel for the
I know, I'll
state
do the garage
are
thing.
present. Counsel for defendant are present, as is defendant Kouri Richins. Let me just provide a summary of how we got from yesterday to today. At the close of proceedings yesterday, we had a plan to receive defendant's written response to state's motion to admit redacted exhibits 8-57R through 8-63R as prior consistent statements under Rule of Evidence 801 D1B. After everybody left the courthouse and upon reflection, the court did some additional research regarding the foundational requirements of 801 D1B, issued a ruling requesting additional foundation for admission of those redacted exhibits under that rule. That's docket 1700-1700. And shortly after that, had a WebEx conference on the record with counsel to discuss the court's concerns regarding the foundation requirements for that rule. Following that, the state narrowed its request to seek, as I understand it, Mr. Bloodworth, publishing, not admission, of portions of only two of the proffered exhibits. That would be 5-58R and 8-62R under Rule 106. Is that correct?
Yes, Your Honor.
Okay. After that, counsel, to their credit, engaged in a productive email exchange regarding their positions regarding those redactions. I think we need to discuss those one at a time now. Is that your view, Mr. Bloodworth?
It is, Your Honor.
Ms. Lewis?
Yes, Your Honor.
Okay. It would help me to just go through these one at a time and talk about
Hey, babe.
what's happening here. So let's start with Exhibit 5-58R, which is the transcript of a May 2nd, 2023 interview of Carmen Lauber. And we begin, as I understand it, I'm going off the 8-58R. Did I misspeak? My apologies. 8-58R.
Francis is looking happy this morning.
I want to make sure I'm looking at the right email here. I'm not.
Oh, I like that top.
Yep. I couldn't find the dog's leash. That's why I didn't take him out the garage.
What the dog doing? I'll handle him. I'll handle the guy. I got to make my coffee anyway. I'm
I'm
going to
not going to be
listen.
able to pause to talk to the people.
Oh yeah. Oh no.
My apologies. I need to print the state's response. One moment.
Your Honor, it's probably the 8:05 p.m.
Yes, that's right. So, forgive me, Mr. Bloodworth, in response to the state's highlights in and around page 75, like lines 1921, the defendant states, quote, "This completely resolves this proffered section, leaving nothing for the court to decide." But then the state, I think, sees it a little differently. Help me understand here.
Yes, Your Honor. The highlighted, I think for the purpose of this discussion, the highlights are immaterial. The highlights related to the 801 discussion.
Okay.
So in the 805 email last night, the state set forth its view by page and line number of the 106 argument.
Okay, so the state's position is that page 65, line 4 through page 87, line 13 from this should be published under Rule 106.
That's correct. And That
Oh, I missed one.
that section of that statement, that section of the transcript applies to both the first and that statement, that section of the transcript applies to both the first and second paragraphs.
Got it now.
It encompasses both of the statements both of defense's statements that are outlined in paragraphs 1 and 2 of the 805 email.
Understood. And so to the extent when we look at
Oh yeah. Oh yeah, we got hail.
58R, to the extent that between page 65, line 4 and page 87, line 13, there are some sections that are not currently highlighted. Is the state's position that those are included in the state's request?
Yes, Your Honor, I think for purpose of this discussion, we can ignore highlighting.
Okay, got it. Let me pause there. Ms. Lewis, take a moment. Take the time you need.
They're just ignoring the whole Carmen thing right now. They have,
I mean, they're talking about the Carmen thing.
I think they're talking about the defense's statements, the defendant's statements. No?
What? I don't think so.
Oh,
I don't think so.
I'm confused.
No, because he came in and kind of gave the whole chain of events of yesterday.
And didn't say that they're done with prior consistent statement?
Well, he's trying to get him in through 106. We know
No
this.
one's saying that sounds ridiculous.
I mean,
I'm trying to complete my own cross redirect that I didn't complete.
right. I mean,
I didn't realize we were ignoring the highlights until right now, so.
Well, I think if it helps speed things along, as I understand it, the defendant didn't have any trouble with the highlighted portions. It's now the unhighlighted portions between 65 and 87 that we
Well-
need to make sure you get an opportunity to respond to.
Actually, Your Honor, we had agreed to letting in all of the highlighted portion on page 75 and 76 because that would be what was related to the statement that I elicited on cross. So
What in the
that's what
actual fuck is going on?
we had agreed to, which is what we believed the state wanted, because like I said, it wasn't until Mr. Bloodworth just said we were now ignoring highlights. So we agreed to page 75, line 8, starting at line 8, through page 76, ending at line 5, under the rule of completeness, because that completed the discussion around the elicited statement, which is give us the details that will ensure Kouri gets convicted of murder. I think going all the way back and adding in everything does not have to do with that
So they're recalling
statement.
Carmen?
It's a lot of discussion. I mean, it doesn't have anything to do with O'Driscoll's
I don't think so.
statement that was elicited through Carmen. It's talking about,
I don't know why the
Try to look at
defense
the
is being
unhighlighted
agreeable to
parts
any of
now.
this shit.
Insane.
And I don't know why my boyfriend isn't telling the fucking.
I mean, it
you
is
know what,
talking about,
counsel? You fucked up by not redirecting her on this shit.
that
Sorry.
it's about she doesn't know the situation between Eric and Kouri, which wouldn't have anything to do with that. It's about when we're going to meet again. She says, I need to go through whatever I need to go through to figure out. I mean, this doesn't have anything to do with that statement by Detective O'Driscoll. I mean, I agree the stuff right before that and immediately after that that completes that line of question and answers should come in. But for example, on page 67,
Pause it.
Detective Maynard says, I'm just saying we're going to need you to settle.
I'm going to make this clear one more time. Yes, Lewis can be annoying. Yes, she takes way too long. What is happening right now is 100% Bloodworth's fault.
Yes.
He did not do his job. After that nightmare cross that took forever with her trying to refresh Carmen's, recollection and trying to impeach her, and it was a nightmare. That dude, Smugworth, had to stand up and go through the same nightmare that she went through with the witness who doesn't remember anything to rehabilitate her at that time with prior consistent statements. I just want this to be clear that every lawyer in this room is shitting the bed. This isn't a defense-only problem. And if you're hearing it somewhere else that Bloodworth is crushing it, you're getting bad intel because he ain't crushing it. This is a Bloodworth problem. We're having to go through this right now, this nightmare minutia, because Bloodworth didn't do his job.
Right. He didn't do what she did.
Right.
Going through every
No one wants to
statement.
do that. No one wants to go through the transcripts because we saw how it's 962 pages. And you're having to do it on the fly. It's clunky. It doesn't look good. So I just need everybody to understand. Go ahead. Feel how you're going to feel about the defense in this case, but understand Bloodworth has sucked in this trial.
At times.
When has he been good?
I mean, he's been all right at times.
Their most important witness in the entire case is Carmen Lauber, and he is absolutely scrambling to try to rehabilitate his most important witness as to the most important charge, which is aggravated murder. So I don't know what you're talking about. I disagree, madam. I don't think that he's been okay at that. I mean, whatever. If you're going to fuck up the biggest witness you have, I'm going to hold you on it. Because at this point, the defense says it's not their case. This is the state's case. I'm just trying to point out to you guys that what is happening right now is 100% Bloodworth's fault. I'm done. Coffee time. And I'll bring the pup out.
Oh, I got to hit play.
Hello?
I was looking at the new rule. They changed their rules 106 last year. So I was just pulling it up. All right, here we go.
Down and get details and timelines. I mean, that doesn't have anything to do with the statement. And it's also hearsay by Detective Maynard. I suppose if Mr. Bloodworth wants to question Detective O'Driscoll about some of these other statements, that would be appropriate, but I disagree that all of this comes in under the rule of completeness.
I think we need to be a little bit careful here. It's not Detective O'Driscoll's statements that are subject to the rule of completeness. It is Ms. Lauber's statements.
And it
that
needed to be done at that
as I understood the
time.
state's position.
It needed to be done at that time. What in the... I just don't understand in what world you challenge somebody with a prior statement and they are not if he needed time on redirect to do it, then he should have had it. The rule says if a party introduces all or part of a statement, an adverse party may require the introduction at that time of any other part or any other statement. That, in fairness, ought to be considered at the same time. This is not, I have never seen it used this way. It's boggling my mind that they're using this way. This is just normal cross-examination, redirect. Cross-examination, redirect. The rule of fucking completeness, you should have just asked her about it when you had the time. This is not, she did not introduce the actual statement. That is what this is for. She did not introduce the actual statement. She just asked her questions about the statement. Did you say this? Did you say that? And then they should have said, well, but didn't you also say this? And didn't you also say that? I'm so confused, and I don't even know if I can say, well, this judge knows his shit, so I guess this is the way they do it in Utah. Because yesterday, not a damn person talked about the fact that those statements are not prior consistent statements because they were not before she talked to the police. Okay, let's just go.
It was the context provided by Detective O'Driscoll's statement on page 75 combined with Ms. Lauber's response on page 82. And that was, as I understood, from back when Carmen Lauber testified in open court, what the state believed they needed to correct the arc of. Is that fairly stated, Mr. Bloodworth?
It is, Your Honor, and I can provide additional detail to the extent we need it.
If you would
You
just
need it.
make a record for why the state believes page 65, line 4 through page 87, line 13 is required to explain, qualify, or provide context for Ms. Lauber's testimony, I'd appreciate it.
Your Honor, the necessary context is that Carmen Lauber was agitated about her involvement in Eric Richins' death, and that detectives were trying to settle her down and focus her in on the details. The court can see the word details in this portion of the transcript appears a dozen or so times as Carmen Lauber is scattered. They're trying to just get her focused in on the details, and in the details, and explaining to her, right? Because the broader context here is they're talking about her immunity, and they're explaining to her that details are necessary so that they can corroborate them, and that corroboration of those details is necessary for immunity. That is the context of the statement.
Ms. Lewis, go from there, please.
Sorry, just a moment.
Your Honor, if the state could add, that is the narrowly tailored context of the statement. The state, water under the bridge, but the state has argued the entire series of interviews provides that context as well.
That's been preserved.
It has. I appreciate that.
I'm not going to talk about it anymore because it's driving me crazy.
Well, I understand what they're saying. I don't disagree that all of that is necessary under the rule of completeness. So I would just stand by our objection that really what should come in is the complete statement on page 75 and 76. I will say, in looking at this though, I was already, when we were looking at it previously, just the highlighted, I really didn't have a problem with through line on page 82 through line 17 on page 82, because I actually do think some of that came in during cross. I'm not probably like to take out the stuff between, well, no, that's okay, never mind. So I really don't have a problem with line 8, starting with line 8 on 75 through line 17. Although, I'm sorry, Your Honor, this skips. I mean, we go from 76 to 82. So
No, the state's request, and I can appreciate why you just need a moment to walk through it. But sitting here this morning, the state's request under Rule 106 is to publish, among other portions, page 65, line 4 through page 87, line 13
all right,
of
so
this.
you also want, which you didn't include.
All right. I'm just going to say, I can't stop myself.
Get him, babe.
I'm
Get 'em.
looking at this. I'm looking at the notes of decision on the rule 106 in Utah. Okay. And it specifically says under oral statements, every rule introduce,
Yeah.
allowing
Wait,
introduction.
you were breaking up.
I'm
You were
breaking up?
choppy. You
Am
were.
I still choppy?
I
I'm
don't
not
think so.
choppy anymore.
We missed
Okay.
the very beginning of.
All right. Evidentiary rule allowing introduction of previously unintroduced portions of a writing or a recording, which ought in fairness to be considered contemporaneously with the previously introduced portion, applies only to writings and recordings and does not apply to the admission of oral statements. Did someone play a recording, a portion of a recording? This is what I'm not. The defense did not play the recording. She asked her about her oral statements that happened to also be recorded, right?
Yeah, they were recorded and then obviously transcribed. So,
But she
which
didn't.
doesn't constitute writing in the way that they intended to in that rule, in that note, right?
I don't think so. I'll have to read the whole freaking case. I've just never seen it like this.
Here, read
You've
it one
got
more time. Just read the last portion.
applies only to writings and recordings and does not apply to the admission of oral statements.
Right. So explain, because I was telling you, I think that there were a couple of clips of the interview played by the state, but I could be wrong. It's been 8 days. I can't remember. That was a nightmare examination all around. So I can't remember. If y'all remember in the chat, because there were definitely a couple of clips of the interview that were played. I think I could be confusing it with Crozier because I know they played Crozier like in the interrogation room. I know it, but I thought that they played. I can't remember, to be honest with you.
I don't know how the defense could have played Carmen's statements because they're unless they were impeaching her, which I don't think they were because she kept saying, I don't recall. So they were refreshing recollection. And if they're refreshing recollection, you don't actually play for the jury the portions of the recording.
Right. Unless they were playing it for her individually with headphones on.
Well, now this says tape recording and transcript of defendant's oral statements to police constituted a writing within the purview of the rule, provided that when part of the writing of the recording statement was introduced by the party, the adverse party could require introduction of any other part of the writing or recording of the statement, which ought in fairness to be considered contemporaneously on redirect, on cross, not at a different time when it's like, I just don't understand what's going on.
This is not Ramos's gamut here. I know everyone loves Ramos because he reeled it in from being a dickbag initially. He's fine. He's like 8 years into his legal career. Ramos is not the answer here. This is an issue. Again, I'm going to say it one more time. I'll say it much more calmly. This was an issue entirely the state's fault. It's exactly like Allison said. If he needed time after the cross, because that was near the end of the day, the judge would have happily said, if he would have stood up and said, Your Honor, I need to redirect her, but in light of what just happened with this 6-hour cross-examination with the nightmare refreshing recollection and everything that just happened, I need overnight. I'd prefer to pick it back up in the morning after I've had the opportunity to see what I need to pull from the transcripts in order to have these prior consistent statements come in order to rehabilitate her. And the judge would have said, fine, because we were at the end of the day. He didn't do that. So we're at this point right now. Like, I'm disappointed that the judge hasn't at least said to, like, not in the presence of the jury. And maybe he said it back in chambers during this WebEx meeting. He would have said, Bloodworth, you should have done this on redirect. You know it. I know it. We all know it.
He limited him, I guess, at some point. He keeps saying that he limited him in some respect. So
Who?
maybe the judge. So maybe they did have. If they had a WebEx, I didn't know they had like a WebEx meeting.
Well, yesterday, pertaining to this.
After they decided it can't come in as a prior consistent statement, is what you're saying, right?
Yeah, no, I'm just talking about it any time, because I'm telling you, Bloodworth has been scrambling for days to get this shit in. The day after is when he tried to get the entire transcript in, the day after Lauber's testimony. So for the entire time since that time, he's been trying to desperately figure out how to get these statements in. Because I don't know if there's a prohibition against him recalling her other than it looks really bad. And
No,
I don't know how that works. How does that work?
No, if he needed to call her on an issue that he I don't know.
I mean, right.
You don't get a second bite at the apple. Like, I forgot to do something.
Right. Yeah, I forgot to rehabilitate my witness.
Yeah, I need to
my most key witness.
I need to complete the redirect that I didn't complete. It was very incomplete, and I need to complete it. But then they need to call her. I mean, but they're not talking about that either. So
I didn't see your water. I'll grab you water now.
Oh, thanks, babe.
77 for. That's where you've lost me.
So there's a gap in what we're looking at pages 77 through 82.
Is there?
Yes. But they've provided that they wanted jump from page 76 to 82.
I'm so sorry, Mr. Bloodworth. I'm reading your email of 8:05 p.m. 65 line 4 through 87:13 inclusive.
Correct.
Okay.
That is correct. I think that the disconnect here is the pages we're looking at.
Jump.
She's looking at jump. Yeah.
Oh, okay.
So now you want the pages you don't have your
I did not appreciate that. I've got to see the other pages.
So do I.
Yeah, my apologies.
I think
I'm redacted.
here's what we'll do. Page 65,
I didn't
line
watch the whole
4,
thing because I was
through
still
page
doing
87,
the other
line
trial.
13.
87?
And just to go completely off track for a minute and circle back to the whole prior consistent statement, for those of you that followed the Faust trial, they had this issue there. I was screaming to Bob at that point, like, why in the hell are they letting the ex-boyfriend's statements in as a prior consistent statement when they're the same statements at issue? They were the same statements he made to the police, not ones he made before the police interviewed him. And they let that in there too. At least the judge righted his wrong here, but now I feel like we're still doing something wrong. But
Minus pages 77 through 81.
Okay. So now we're back to
We're
the
back.
proposed
This will take us here
5-58R.
just in a more efficient way.
Yeah, that's fine. Okay, so Ms. Lewis, my apologies. Now I think we're all on the same page regarding the paper version of 5. I keep doing that 8-58R that we're looking at. Thank you for raising that. So just so the record is clear, we're currently contemplating page 65, line 4 through 7625, and then 82-1 through 87-13.
I would agree with 76 starting at line 8 through the bottom. I'm sorry, 75 starting at line 8 through the bottom of 76. And I'm all right with page 82 through line 17, but we would object to the rest.
Okay, bear with me. All right, so the court is persuaded that the statements of Carmen Lauber elicited on cross-examination, as indicated on proposed exhibit 8-58R on pages 75, line 19 through 22, 82 lines 8 through 11, and page 86, lines 17 through 19, require, under Rule of 106, context, qualification, and explanation in the form of additional portions of 8-58R. And those additional portions are page 65, line 4 through page 76, line 25, and page 82, line 1 through page 87, 13.
And he's letting them do
Any
that with the
clarification,
actual
Mr.
video.
Bloodworth?
No, Your Honor.
Okay.
She didn't
Ms.
play the
Lewis.
video.
No.
All right.
No.
Somebody said that they played a
So
couple.
I think
clips.
that handles
Actually said they played
bulleted paragraph or numbered paragraph.
Oh, the defense actually played some clips.
I have no reason to doubt Ashley. She says they did. So, and Mavka supports it. So yeah, it sounds like the defense played a couple of clips.
Okay. Well, I guess all my screaming and yelling.
Paragraphs
It's
1 and
still fucking
He
ridiculous.
still should have done it on.
I've never, it's just, let me like,
Here's what I'm going to say. I think the judge must
Bloodworth
think,
is no Georgia Kappelman. Let me just
No.
put it that way.
no, and I think the judge must think the defense mischaracterized it so badly that he's allowing the prosecution to do this, because he made a comment. I can't remember if you were on for it, babe. I don't think you were, actually, where he said that he believes that the state has evidence that demonstrates that how the defense characterized testimony was like unfair, basically. So I think that might be playing into why he's allowing this kind of remedy, is that he felt that the defense mischaracterized something to such an extent that the state needed time to be able to do all this.
Yeah, I mean, there were portions where I think, and I don't know that it was intentional. I mean, maybe it could have been. If it was, shame on Lewis. You know, if she was misstating things purposefully as opposed to just being sloppy, because they're two different things. Neither
Well,
are
we're
good.
talking about whatever portion she played of the interview, because I think that's got to be.
Well, but the interview speaks for itself.
Yeah,
You
but
know
if
what I'm saying?
take it out of context and
Well, I mean, that's the whole point of the completeness doctrine. You know, I mean, anything that's cherry picked for me is taken out of context.
Yeah.
You know, that's why the completeness doctrine
let's
exists.
not
You
jump
need
down the
context.
rabbit hole of Richard Allen.
Oh yeah. Oh yeah.
Oh yeah.
No, Chrissy CC, we are die in the wool defense attorneys.
That
I
doesn't
see-
mean that we're gonna decide at the end of the day that there's not sufficient evidence against.
Oh yeah, I don't give a shit. I I
Against-
call it like I see it. You know,
Kouri
if I think they prove the case, they prove the case. Period. End of story. I got no dog in this hunt. I don't know Kouri Richins a damn thing. So I'm just telling you right now where we sit. Where I from my personal opinion, they have not proved aggravated murder. They've proved a lot of other charges. You know, I don't think they've proved the attempted murder, and I don't think that they've proved the aggravated murder at all.
Well, I'm pretty far off on the attempted murder. I think that's, but the only way you kind of get to the attempted murder is if you believe. I mean, I don't know.
You got it right.
What happened?
It's
What
not.
happened to poor Bobby G?
It's
What
not.
happened to his dog? What
Oh
happened
my
to
God!
poor
Don't get me on
Bobby
the hush
G and
puppy
his
shit
dog?
again. I don't know if you were on when I was talking about. Somebody sent me a DM on X that just blew my mind. And it was that maybe you were on. It was the concept being that whatever this hush puppy thing was, if it was like an actual tangible piece of food, that maybe he gave a piece to his
I never
dog.
said that. That's why I said his.
Yeah.
That's why I threw that out there.
Yeah.
I mean, I
I
might
mean,
find her fucking guilty of attempted murder just on those things.
just on a poor pup dying.
No,
Yeah.
I mean, like, what? How are all these people
it's
dying right around
suspicious.
the time that her husband's getting sick and she's buying drugs? And
But why isn't the state dipping into that? Like, why wasn't that addressed at all? It's driving me crazy. It's crazy to me. That's such a smoking gun. To me, that wins the case. If they're like, Kouri brought over a batch of hush puppies she made, and dude eats them, gives his dog a little bite of one. He feels he's wiped out for the whole day, and then his poor pup dies the next day. She's done.
I mean, I think he would have tied those two things together in a
Right,
message.
dude.
I wiped out,
Wait,
and my
who's
dog is
he?
dead.
Smugworth?
Josh, Bobby G.
I don't know if Bobby G would have.
He seems pretty smart.
I don't think anything's obvious, Mal's. I disagree with you on a lot of things, but on that one, I definitely disagree with you. I don't. How do you know?
How do you know?
How do
All
you
right.
know?
All right, let's go.
Let's go.
And two, in the email exchange between counsel, correct, Mr. Blover?
Yes, sir.
Okay.
Let me
That
see
brings
what
us
it
to the equals bulleted or numbered paragraphs 1 and 2 in the email exchange between counsel, correct, Mr. Blover?
Yes, sir.
Okay. That brings us to
Hush puppies can be a drug.
numbered
Hush puppies
paragraph
are
number
not a drug.
3.
They're a food.
Bear with me.
Man, crazy world. I've been eating hush puppies from Long John Silver since I was 10 years old.
Yeah, there's nothing online about a hush puppy being a drug, a slang for drugs.
No, I saw some stuff. Like,
Really?
Yeah, it's like, I mean, but you can find anything online.
So here, to provide additional context, qualification, and explanation for Ms. Lauber's statement that I get that related to the get out of jail free card, Mr. Bloodworth, I understand the state is requesting publishing 114 line 6 through 115 line 6. Is that right?
Correct, Your Honor.
Okay. Ms. Lewis, go ahead.
Your Honor, I think the discussion about what Ms. Richins is doing, about the children and the relationship with their father, all of that doesn't add any context to what Detective Maynard's statement is. I mean, I guess I'm not opposed to going through line 12 where she says, "Oh, I get that," but the rest of it it's also quite prejudicial.
Why is it prejudicial? I mean, it doesn't matter if it's prejudicial. I don't have any discretion here if it's required for.
I understand.
So
I mean, the fact that he says you're on what your get out of jail free card looks like based on the information that, and then he says there's 3 little boys that don't have a dad. There's a family that doesn't have a brother. I mean, what does her response about the boys and Eric have anything to do with the fact that she now has a get out of jail free card if she gives them her information?
I understand the state's position to be this shows what her motivation, the complete version of her motivation, rather than just a motivation to serve her own interests. Is that about right, Mr. Bloodworth?
That is, Your Honor. And Detective Maynard couples the two in his statement. It's get out of jail free card looks like, based on the information, that there's 3 little boys that don't have a dad. He's coupled them.
I'm sorry, can you finish?
Yeah.
I don't know why just going through line 12 where Ms. Lauber says, oh, I get that. Why doesn't that complete that she gets that that's why it is because of this reason? Why do we have to go into the rest of the relationship with Eric and the kids and that Kouri's living her life while everybody else is suffering? I don't understand how that completes anything more than just ending with Ms. Lauber's statement at line 12, that she understands that's why it is because of the circumstances.
Mr. Ludwig, go ahead, sir.
Your Honor, it completes Carmen Lauber's expression of her motivation to cooperate.
Okay. Having considered the arguments of counsel and looked at Carmen Lauber's statement on page 114, line 12, the court is persuaded that under Rule 106, publishing of page 114, line 6 through page 115, line 6 is necessary to explain, qualify, and provide context for her response.
I mean, if you're the defense, you're like, whatever.
All right.
Like, they're going to be playing some clips out of context through O'Driscoll. Like, I don't understand, like, how's the jury supposed to know what this means, why it matters?
Pages 182 and 183, correct, counsel?
Yes, sir.
Okay.
Well, hopefully the defense is prepared to pick out every little threat that they made to cross him on. Well, but you also said this, and you also said that, and you also did this, and you also pushed this, and then when she said this,
Wait,
you said
so
that.
is that how you think this is? So they're going to put O'Driscoll on, and then on during direct, so if he's limited to only giving direct examination type questions, how is Bloodworth going to navigate through that? Like how is this going to be introduced to the jury in terms of what they're attempting to do right here, which is, okay, you guys remember the lady that came on, the nice lady who,
I
was
think they're going
crying
to do
and
something like this, Bay. They're going to say, you interviewed Carmen Lauber, right? Lauber.
Lauber.
And she, although she expressed some desire to get out of trouble, she had other motivations for cooperating. She expressed to you other motivations to cooperate. Yes. And in fact, she expressed to you, but I just
Objection, leading.
well, I know.
I mean, what? That's what
I
I'm
don't know.
saying. Like, unless he's going to give him some heavy duty leeway in terms of his
Sounds like he
questioning,
is.
I don't know how he's going to do it. He's going to have to allow him to lead a bit.
Right. And you recorded this, and this is a true and accurate. But are they actually playing the recording? Because I keep forgetting the defense actually played some of the recording. So
I don't know if it's going to be like they keep talking about the transcript. So
right,
I
but
don't
then
know
I
if
think
they're
he's taking the transcript and using it to edit the audio video to play, certain portions.
maybe because they're going to have time once they wrap up here this morning
Yeah,
to,
they got till 1.
to pull it.
One their time.
Because like if the state's plan is to put it up on the screen and just have the transcript roll by, like Bloodworth has done everything
they're
that's been in
not.
writing, is going to be ridiculously bad,
Yeah.
totally ineffective,
Yeah.
completely. It's going to be completely lost upon the jury. They're going to be like, okay, I don't like
By
it.
the way, I've got an 11 o'clock meeting. So
Meeting.
yeah.
Do you have to see a man about a horse?
Yeah, I got to see the meeting.
Oh yeah. Oh yeah.
Whoops.
So here, the statement that the state seeks to provide additional context, explanation, and qualification for is Ms. Lauber's statement on page 183, line 5. Can you guys just write it and I sign it? Correct, Mr. Bloodworth?
Correct, Your Honor.
And the state's position is that under Rule 106, we're required
She
to go
didn't play
back to
that.
182 line 12 and include through 183 line 14.
I heard that. She did not play that as a clip. That was a direct question.
Well, I think
Maybe.
what was happening is they were refreshing her recollection by playing the clips with her listening only to refresh her recollection.
Oh,
So they
that
were
doesn't
playing
count then.
I don't remember them playing clips for us. I remember them
jury.
playing clips for her, right, for the jury, for her with the headphones on. I remember that.
Yeah, that
But
doesn't count.
they might have. I'm certainly not saying that they didn't. I just don't independently recollect it myself. I need my recollection refreshed. I don't,
Nobody says
dude,
anything.
DB. I
DB,
couldn't tell you,
I'm with
dude.
you.
It's like that's so many days ago.
It's like, all right, let's just keep going because we're never going to get over this.
Do I have your position correctly?
You do, Your Honor, and that necessary context is that the detectives needed Carmen Lauber to put her verbal statements on paper, and that detectives were not able to do it for her.
Actually, I'm fine with that. I think there was a typo in what we said in our response.
Okay. Very good. The court is. Oh, I'm sorry to cut you off, Ms. Lewis. Go ahead.
No, I'm sorry. I was just saying in terms of the lines we agreed to, I think that's just typed incorrectly. That's not a problem.
Okay. Under Rule 106, the state is permitted to publish line 182, page 182, line 12 through 183, line 14 from 8-58R.
Yeah, we're talking about interviews with the police. Carmen's interviews with the police.
Yeah, they were very brief clips.
Anything else from 8-58R, Mr. Bloodworth?
No, Your Honor.
Okay. Ms. Lewis?
No.
All right. That brings us to 8-62R, correct?
Yes, sir.
All right. We go to page 12. Here, in response to a question from Detective Maynard, the goal is to convict Kouri for an aggravated murder. These parallel drug investigations, those aren't a priority. Ms. Lauber says, right. And the state asserts that completeness requires that we also publish page 11, line 20, through page 13, line 22. Correct?
Correct, Your Honor. And the necessary context there is that Carmen Lauber is spooked by the federal grand jury investigation, and Detective Maynard is assuring her that that federal grand jury investigation is secondary to the murder investigation.
Yep. Bob told me this.
Ms. Lewis.
Yeah, I really think that if we start at page 11, line 20, and go through 12, line 20, that it states enough to cover all of that without getting into the grand jury, which is a whole other can of worms.
Why can't we go to 13, line 7? It gets a little confusing after that, I'll grant you, but 13, line 7, I think, is an important closure on that issue of the potential for federal charges.
I'd like to take out the reference to the grand jury. What if we...
Help me understand, what is it you think is a problem with the grand jury? This is what they're talking about, is federal charges.
Well, they are, but it's clear in here that she's saying federal charges are the next, that's more up the chain serious like the highest extreme. So it's already in here that they're already saying that federal charges are more serious, and he's telling her not to worry about that without getting into the grand jury, which causes me concerns. I mean, that's something we've avoided talking about. It speculates that it's going to allow the jury to speculate about what that means if there's other charges. I think most people don't know what a grand jury is. They may think there's another jury that's made some kind of finding. I mean, we maybe could go through line 7 if we just take out we could even just take out on 13, starting at line 2, just take out that's where it's formalizing it with the grand jury.
Let's talk about mechanics for a second, Mr. Bloodworth. I understand, or I appreciate that these are many fewer pages of transcript than was under contemplation yesterday. Are we just going to show the transcript to the jury at this point, or have we cut the video down?
Thanks, Judge.
Your Honor,
Yeah. Yes.
set the conditions where we can cut the video down. There's still a little bit of editing time, but not much.
Sure.
The state intends to publish as we've published other similar exhibits, playing the video with the transcript rolling beneath it.
Okay. All right. I appreciate that. Okay.
I need to go
Mr.
back.
Bloodworth, talk to me. Why in the state's view do we need to go beyond line 7 on page 13?
Sorry to interrupt, but I'm actually okay if we go through line 10.
Okay. Line
If
10
that
on page
completes the
13.
thought.
That's agreeable, Your Honor.
All right. So, first, the court is persuaded that with respect to state's proposed exhibit 8-62R, publishing page 11, line 20 through page 13, line 10 is necessary under Rule 106 to provide additional context for Ms. Lauber's response to Detective Maynard's question as depicted on page 12, lines 2 through 6. The court is not persuaded that a stray reference to Carmen Lauber appearing before a grand jury will mislead or confuse the jury in any way about any consequences or any investigation regarding Kouri Richins. The defendant's request for redaction of that sentence is respectfully denied. Anything further on that, Mr. Bloodworth?
No, Your Honor.
Ms. Lewis?
No, Your Honor.
Okay. Scott, do you need any of those numbers again?
No, Your Honor, I was following along and I have them down, and I can.
I like that plan. Let me just write this one down. State's motion to admit redacted exhibits 8-57R through 8-63R is moot at the current time. Is that correct?
That is correct, Your
There
Honor.
you go. Moot. No prior consistent statement for you.
Got it. Counsel, last evening I sent out notice of the court's decision denying defendant's motion for mistrial. I'll issue a written ruling providing the court's analysis in the due course, but I needed to make sure that you had notice of that decision. I also gave notice of the court's designing a remedy under Rule 16 of requiring the state to recall Ms. Lauber in its case in chief to make sure that defendant has an opportunity to cross-examine Ms. Lauber about the alleged violation of her drug court probation in November 2023. I know only 12 hours have transpired since that time, Mr. Bloodworth, but what is the state's expectation?
Okay, so for that, I'm assuming you guys remember that after Carmen got off the stand, the defense ranted and raved about they were not told, there was a disclosure violation that she violated her drug court. So the
Mhm.
remedy he is, instead of a mistrial, he's making the state recall her so that the defense can cross-examine her on that issue.
Mm,
That's what he's discussing now.
mm.
Mm.
Your Honor, she will be here at 1 o'clock.
All right. Are we starting with her?
Yes, sir.
Okay.
All right,
Ms.
all
Lewis,
right,
anything
all
further?
right.
Um,
Lauber part 2.
I imagine that nobody will be discussing with her what she's coming back to testify regarding between.
Well, I told her she was still subject to the subpoena, that she was not released. I'm sure all officers of the court will abide by the rules there. You'd be within your rights to ask her if she's talking to anybody
Sure.
in the meantime.
Sure.
I imagine the state will have some limited redirect of her upon putting her on the stand.
Yes, Your Honor. Maybe we can clarify just scope
Sure.
of cross. I think the record's clear in the state's papers that defense has already had an opportunity to examine her on this issue. I appreciate the prophylactic nature of the court's ruling.
Right.
I'm happy to protect the record. But as I understand it, the scope of defense's cross-examination of Ms. Lauber today is limited to impeachment based on the materials surrounding her supervision.
Yeah, even I think more specifically, the material received by the defense pursuant to the subpoena that allegedly revealed this potential violation of her drug court probation in November of 2023. That's the new information.
Okay, and as I understand, that new information is an unsigned affidavit, although substantively that affidavit is no different than the information provided pre-trial.
Yeah, that was a little unclear from the papers as to whether the subpoena response gave more detail than what was provided pre-trial. I honestly don't know.
Yeah.
And I want to be clear, this will come out in the court's oral ruling.
Sure.
The
Yeah.
court is not making any finding that the Summit County Attorney's Office intentionally withheld any information, but the knowledge of Detective Maynard is imputed to the state, and so we are where we are.
Your Honor, I appreciate all that. I think the only information in the subpoena return that was new was a printout of a link to a drug test result, the link which has long expired. So,
Was the unsigned declaration provided prior to trial?
Your Honor, it was not, but all the substance
I
in
see.
that unsigned declaration was provided prior to
Okay.
trial.
Well, to prevent any
Sure.
infirmity on appeal, my view is that the scope of this recross that the court is providing the defense an opportunity to do are the facts and circumstances related to any potential violation of Ms. Lauber's drug court terms and conditions in November of 2023.
Understand.
Ms. Lewis.
Just some clarification. Well, first, the only information we had before was that she apparently had drank alcohol. The information about the circumstances surrounding that is new. But the other thing, so I included in what the state sent us was the letter that Carmen Lauber sent to Judge Mabee, which I did have before, but I didn't question her about it. But now I would like to point out that what she says in that letter is not accurate.
What's the date of the letter?
February 15th of 2024, where she says that she's been in 100% full compliance. Well, now we know that she's not been in 100% full compliance. So
I don't know if we know that. We know that she was observed holding an alcoholic drink. We don't know if she ever consumed it. And so, I suppose if you want to ask her if she violated her condition of not possessing or purchasing alcohol, you can ask her that. But,
Your Honor, I'm not sure that's
now it says she was consuming it here.
well, that's an unsigned affidavit. We got to be careful. That's not evidence of anything. It's just words on a piece of
But
paper.
he gets to ask her. She gets to ask
You can
about
ask
it.
her about it, but we can't admit that. Go ahead, Mr. Blood.
Your Honor, the letter to Judge Mabee, I believe, has been in discovery for years.
No, and Ms. Lewis is not suggesting otherwise. It's just she's not suggesting now she has, in her view, evidence that the statements made by Ms. Lauber in the letter are not true. And so she now has a reason to ask her about that.
Understand.
So, and I'll loop back, but you can tell by the words the judge is using, he does not think that the defense's point is a good point. He's balking every chance he gets. Well, we don't even know that she consumed it. Well, this says she consumed it. Well, that's an unsigned affidavit, but is it still a prior statement made by the? I mean,
It wasn't signed.
Yeah, but if she
You
admits,
know how often lawyers actually draft up affidavits and then they'll send it off to the person. Is
you're
this
saying
accurate?
she didn't draft it.
Obviously.
Right.
Like I
Right.
don't think there's any world in which Carmen Lauber drafted her own affidavit.
Right. Okay, got it.
And then we were provided also
He's
this,
got a good point.
I guess it's a screenshot of text
Police report
between
with words on paper too.
Ms. Lauber and Detective Maynard that we just got.
Sorry, Bob was just saying that the judge is making a good point because them's just words.
No, I'm saying DB's making a good point because police reports are just words on paper too.
Oh, see, that's why I paused it so we could hear what you were saying.
Mm-hmm.
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 All right.
Also for the first time that I didn't have, so I would like to ask her again. And then we were provided also this, I guess it's a screenshot of text between Ms. Lauber and Detective Maynard that we just got also for the first time that I didn't have, so I would like to ask her again about her communications and her supervision.
As long as you're within the dates of those text messages. Unless they had those as well. I don't know.
Your Honor, they don't, but she testified to exactly what the text messages show, so I don't know if there's any impeachment there.
And is that true?
She testified that, off of my memory,
Yeah.
she testified
Say you're
that
low, babe.
her check-ins with Detective Maynard amounted.
What?
People are saying your mic's too low. You need to.
Maybe
Bump
your
it up.
mic's too high.
Wow.
I will. My mic is low because we had this before. We had it set to.
Yeah, I think
You
you
have
have
yours back on auto.
No, no, I'm at. But I don't go as low as you do. You go into the 30s. I usually go like I'm at like 72.
Oh, yeah.
Oh yeah.
All right. I'll go.
Oh yeah.
I'll go to 52. I'll go to 55 because my mic's stronger than yours, right?
Yes.
Okay, here
Well,
we
you've
go.
got the interface.
I got the interface.
You got the interface.
To one of them texting Lauber, the other responding with Maynard, which is precisely what the texts show. So in fact, I think the text messages are 100% entirely consistent with Carmen Lauber's testimony.
Ms. Lewis, let me look at the text with you for a moment. My apologies.
That's fine. I would need to look at that portion of the testimony again, because maybe my recollection is incorrect, but I know she also testified about a lot of communications with Detective Maynard. I mean, I think it would be appropriate to ask her if these communications were in text, because the text don't include that. And I don't know why we have just a screenshot of a week of text. I mean, this is incomplete.
Well, but Ms. Lauber's not going to know why. That's what you received from the subpoena response. You can ask Detective Maynard about that if you want to call him.
If you want to call him.
About why we only have these dates. Is that what you're talking about?
Right. Ms. Lauber won't know why Detective Maynard or the Summit County Sheriff's Office did or didn't
right.
produce
I wasn't
additional
gonna-
records.
I wasn't going to ask her that.
She
I
wasn't
was talking
suggesting
about
that, count,
if
Your
this
Honor.
is a fair representation of all of her texts. I mean, I was
All of her texts for Saturday, February 14th through Monday, February 16th.
Well, I think I could ask her if this was a representation of her text throughout her supervision, if this is what they
There's no. What's the foundation for the fact that they only texted for 3 days in February of 2024?
No, what I'm saying is, I think I can ask her, show her this and say, are these 3 days a representation? Is this how you always communicated with him? Not just these 3 days. Does this represent how you always communicated with him?
I'll give you a limited latitude there.
Okay.
Yeah. Fair.
And then,
Fair.
I want to make sure you heard the word limited when I said that.
and then I need to look at exactly what she said about that before, but I may have some other questions regarding how they communicated other than these texts.
Take a look at it. Let me know if you want to readdress this prior to 1 p.m.
All right. Let me just make sure that's everything.
Now, to be clear, my view is that because we're in the
Steve-O?
state's case in chief and we're recalling one of the state's witnesses, Mr. Bloodworth, if you want on direct to direct examine Ms. Lauber regarding the November 2023 events, if any, you're permitted to do so.
Yes, sir.
Okay.
All right, I think that's it.
Okay. Let me pause there. Anything else on the record at this time, Mr. Bloodworth?
No, Your Honor.
Am I correct that the state's intention, as we sit here at the moment, is to call Ms. Lauber and Detective O'Driscoll today?
Correct.
Okay. Do you have any intention, as you sit here at the moment, to call any other witnesses in the state's case in chief?
No, sir.
Okay. Understanding we may or may not get Detective O'Driscoll done today, but certainly will sometime tomorrow.
How could
Does the defense, if it plans to put on witnesses, that's your prerogative to choose whether or not to do so, have a couple or more in the wings for tomorrow?
We do.
Okay, very good.
Oh,
All right.
it's resting.
States
got
resting. At first, I thought he just meant for today, and I was like, that seems like a short.
Anything else on the record right now, Mr. Blibber?
No, Your Honor.
There we go, kid.
Definitely want to need to take a break after they rest to do our Rule 17 motion.
Fine.
And we also, while we're talking about scheduling, we've got plenty of time here. We would like to build in a little bit of time to have a conversation with our client upon their arresting. There are some decisions the client will need to make.
Oh, yeah.
And we may need
Oh,
about 30 minutes to do that.
No problem. No problem. Okay.
Testify.
Anything else on the record this
or
time, Ms.
not
Nestor?
testify.
All right, folks, we will be in. Thank you.
Wow.
Wowzers. Whoa.
Wow.
Whoa. What do you kids think? O'Driscoll's the final shot across the bow for the state.
That walk the
Resting.
dog letter.
Walk the dog letters coming in, some jail calls, all the stuff. We'll see. Wow, exciting stuff.
So I was wrong. My meeting is at 1:45 our time. So
Oh,
probably right in the heat of something.
well, no. So they're coming back at 1 their time, which is 2 our time. So we'll go through a couple of things here. I'm setting a new live because I'm not going to try. I got to go to the store and get bone broth so I can cook that corned beef. So I got to do that. But what I'm going to do is I'm going to set the new live,
The new.
for 1:45. So we're back 15 minutes early prior to trial starting. So everybody can go eat breakfast, do
They can
your
have time to
morning
have any-
yoga,
They're
walk
thinking,
the dog, get your
I got
actual
these
dog.
questions for
Got all
Allie
the
and
stuff.
Bob. Wait,
all the
before we
questions.
go, make sure we've addressed everything. Did you do all this?
What?
Michael
What?
T16 off
Hold
topic.
on, hold on. I'm setting this new
All
live.
right, you do that. I'll read.
Okay.
But excommunicate the Ravens.
Yeah.
I'm assuming that's a sports thing.
That's sports ball. The Ravens retracted on the huge Max Crosby trade, which has put the NFL world ablaze. So, yeah.
I need to go to the bathroom.
I played that for Marissa. Love
Thank you.
dogs.
Thank you
Thanks
very
for your
much.
continued support.
Thank you very much.
For 3 months. Miss Rattle, thank you for your generosity.
Oh, and by the way, if you've donoed this morning, the wheel spin for this afternoon will all carry over. We're doing another huge sticker giveaway.
It's huge grift.
Millions, huge grifting, massive grifting, huge grift. But everybody who donated this morning, you're
on the wheel. You're on the wheel. I didn't know about the wheel. So you're on the wheel and you're on the wheel.
You're on the wheel.
All right. So Christy, let's get this wheel going on this crappy weather day in Iowa.
Here too.
Oh.
Shit day. We had huge storms.
NOLA is for livers.
Yeah.
Yeah.
What'd she say? I'm still not there.
She's a new member.
Oh, family.
We love NOLA.
We do. And we love NOLAs for livers.
What does that mean?
I mean, come on, dude. It's
Like
a big
people who
drinking
live?
town.
Livers.
I'm assuming that it has to do with the amount of drinking that happens in New Orleans.
I was thinking
Which
it's
is
for people who live.
a lot.
Like,
Maybe I'm wrong. Wouldn't be the first time. I
but
promise
welcome.
you that.
We love you. We love your town. See you second weekend of Jazz Fest.
Oh yeah. Wait. I feel like
Cigarette hush. Apply to see Bob rant immediately. I miss them. Bob starred this. Amy says Kouri must be thinking, I wish I had a better defense team.
I bet you the Richins are thinking, I wish we had a better prosecutor. Is Georgia Kappelman available? Because we'd like to bring her out to Utah and have her try the case. Because Georgia, she knew the facts of that case like the back of her hand. That whole kerfuffle with forgetting to or avoiding like the plague, trying to rehabilitate his witness, namely Carmen Lauber, never would have happened on Georgia Kappelman's watch. I'll tell you that. She'd been ready to dig in.
All right. Julie Jensen says Nestor is also assigned to defend Charlie Kirk's killer.
Yep. True story.
Yes.
All right. So let's see. Okay, I got
Ashley
that.
says, in her opinion, the state's star witness is the walk the dog letter, not Carmen Lauber.
Yeah, well, first of all, that's not a witness.
Well, she
I think
knows.
ultimately, I do not disagree. I think ultimately, if and when they convict her, it's going to be because of the walk the dog letter. I completely agree. I think
I
that,
feel certain she's getting convicted. Just the way
yeah,
juries work.
that's how juries work. I
there's
mean,
no
you know,
and the state may
she's
wrap
getting
this all up.
convicted in spite of Bloodworth's work on this trial. Is the way I'm looking at it. In spite of his work.
Cody is upset with the NFL. Thank you, DD family. And thank you for continued support, Cody.
There are too many things to list, Kyle. Too many things to list. Here's the reality of the situation is that, you've got all this evidence, which is powerful circumstantial evidence of motive. Like everything that we've heard, very powerful theory, narrative driven evidence. They have produced no evidence to me that I felt was enough to get me over the beyond a reasonable doubt hump on aggravated murder, which is a specific intent crime, to prove that Kouri Richins knowingly got fentanyl and did it with the express intent of killing Eric. They have to prove that beyond a reasonable doubt. Just saying she got some drugs ain't it. Because you know what? I don't know how many hydrocodone you'd need to kill somebody, but it's a fuck ton. It's not the same as fentanyl. Fentanyl, you're talking about nanograms.
I just think if Eric was a drug user, consistently getting drugs, you'd see some coded messages in his phone. That's
maybe not.
All right, Melissa says,
And how do we
love
know
you.
that he didn't have a burner?
Maybe. Love you from Joliet.
Hey, love it. Thank you.
Right around the corner.
Right around the corner, right around the price.
Claire says, I want to be on the wheel. You're on the wheel. You're all on the wheel.
You're on the wheel.
So we good? We ready?
Yeah. All right. So what I've done, y'all, is I have portaled you to the new live. You don't have to do anything. Obviously, if you jump on and watch, she's a former prosecutor. I don't know that Emily's ever been a defense attorney, so you're going to get that slant from her. The same way you get a defense slant from us. I ain't sweating her on it, but it's like, I think the problem between prosecutors and defense attorneys in general is that prosecutors tend to be very myopic, very narrowly tailored, whereas by operation of our profession as defense attorneys, we have to be objective because we're trying to figure out every possible scenario in order to throw it all against the wall to see what can stick in a case where we're trying to establish reasonable doubt. So, it's just, we have different goals, which if you do it over and over and over for years and years and years, that's just how you view shit, because once the prosecution in any case narrows down on one person, everything else falls to the wayside. No other possibility exists in the world, in their brains. And that's it. That's it. Right. For defense attorneys.
I have watched Emily before, and I've seen her be, fair. I've seen her calling out the prosecution on stuff. I've seen her be, but yeah, she's a prosecutor, so you're going to get her lens on that. But
yeah,
so
I have heard that in this particular trial, here's the thing, and it's the thing that I'm always talking about in terms of pre-trial stuff, which I love. I love the fact that we're all watching it now, because forever we never got to see any pre-trial motion work anywhere.
But we're tainted by it.
But we are tainted by it because all you're hearing in all that pre-trial work, with the exception of Richard Allen and Karen Reed, where the defense put out their whole theory of defense ahead of time. But in most cases, all you're hearing is the state's theory of the case. And that's all it is, kids. It's a theory.
All right, let's wrap this up so people can do what they're going to do before we come back.
Oh, yeah. Do the wrapping. All right, y'all. We love you. You don't have to do anything. If you're going to hang at other channels, just make sure you come back at 1:45. We will be live again. That's our time. Our time.
And thank you, Salty Georgia. Hopefully you got her. Throw me
Hold
on
on,
the wheel, Bob. Love
I'm
you.
gonna take screen grabs real quick of everybody that donoed right now, so just bear with me. And if you Venmo, Cash App, PayPal, you're obviously on the wheel as well. And I'll shout you out when we're getting to the wheel. So you'll
Yeah.
get the love. You'll get the love on the live as well with the other avenues to donating. All right, hold on. I gotta take a few screen grabs here.
Defense has some witnesses to call, and
I mean, look,
Kouri
the
side-
only way
take your pictures, babe.
I did, the
Oh.
only way the defense is making any headway in this trial, moving the needle at all from where I believe it's going to go, is if they can put on any evidence that Eric was dabbling in pill popping. Like, that's it. Short of that, I don't know. I mean,
Right.
what's gonna happen? Jury's gonna juror, or juror's gonna jury-ish, or juror's gonna do the jurying thing, whatever it is. You know, they convict people in that chair. That's what they do.
All right. Thanks, mods. Thanks, everybody. And
We love you
will-
all. Because without you, I'm just an old man waiting to start another live at 1:45. And
sitting around talking to his wife.
see you guys later. Bye.
After